My name is Mark Mellor. I'm an attorney here in Riverside, California. I got a number of clients in Angeles Oaks, still in these economic times, facing issues of bankruptcy. I thought it helpful to go over just a couple of distinctions between a Chapter 7 and Chapter 13 bankruptcy, if that's something you're thinking about and you're facing in your particular economic situation. Some of the differences between a Chapter 7 and Chapter 13 bankruptcy. Well, the first is the timing. In a Chapter 13 bankruptcy, it takes about 3 to 5 years to complete. A Chapter 7 bankruptcy is done in about 90 to 120 days. Why is that? Well, a Chapter 13 is a repayment program worked out with a trustee where you repay a portion of your debts. Could be 90%, could be 100%, could be 10%. Just depends on your income and the amount of debt you're carrying. But that's a repayment program over a 3 to 5 year period. Hence, it takes that long. And that's the second thing, the second distinction between the two is that's the difference. You're repaying under a Chapter 13 a portion of your debt. Under Chapter 7, it's all discharged and there's no repayment. Secondarily, some of the distinction is that you've got a means test in order to qualify to take a Chapter 7 or file for Chapter 7 bankruptcy. Chapter 13, no means test required, and that's because you're repaying a portion of your debt. But you have to qualify in order to discharge all your debt under a Chapter 7. And in order to do that, you have to meet the California statutory median income for your household and your particular household income providers, and number of dependents you carry and all your deductions and whatnot. It has to fall below the California median income. And that depends on how many you have in your household and whatnot, but it's statutorily provided for you. And you've got that. You've got to beat that or fall under that with all your deductions before you can qualify to take a Chapter 7. Assuming you do qualify, we can file a Chapter 7. If not, you're relegated to the Chapter 13 process and the 3 to 5 year repayment. The third thing is that you want to take a look at some of the restrictions in bankruptcy. I think this applies to both. Had a case recently where a client had a spousal support judgment against them. They wanted to get rid of that in bankruptcy. Unfortunately, there's a number of debts that you cannot get rid of in bankruptcy, spousal support or child support being one of them, tickets, state or city government fines, second one, taxes, a third one, there's a limited circumstance and exception to that if the taxes are over a number of years old. For the most part, taxes are non-dischargeable. Student loans, non-dischargeable. There's a couple of other items, but for the most part, all debts are dischargeable, but a few of those items. So you want to make sure that you're not filing bankruptcy to try to discharge one of those items. Another question I get in bankruptcy, whether it's Chapter 7 or Chapter 13, is can I keep a credit card, not have to declare it so I get to keep it, or not declare a bank account, or not declare an asset, or not declare a debt to a creditor because they're a family member or I don't want to discharge that? The answer to that is simply no. You sign declarations when filing a bankruptcy that you are declaring all your assets and all your debts. And in order to fill that out correctly and under oath, you have to declare all your assets and all your debts, meaning you can't hold back a credit card, you can't hold back a debt to a family member or something of that nature. You've got to declare everything if you're going to file. Anyway, those are some of the distinctions I wanted to make for you. If you have some particular circumstances or debts or assets that you're concerned about, feel free to give my office a call and we'll go over those in particular. There's something else.